we are live streaming on YouTube so that any victims may take part without having to come to court. And so the rule stands that no one may, order stands that no one may copy, record, or redistribute any portion of this live stream. And a violation of the court's order may result in a finding of contempt punishable by up to 6 months in the Tarrant County Jail and or up to a $500 fine. And let's see, we had 4 of you and the other one's in the back still, right? Okay, great. So all of you are here for your 10-day detention hearing. As you know, once you have been detained initially, you have a right to have a detention hearing every 10 business days. And the purpose is to determine whether you should be released back to a parent or guardian, or if we should keep you here detained. You have a right to remain silent and you have a right to an attorney. If your attorney who's assigned to you is not here today, then Ms. McGonigal over here will sit in as your attorney for today. All right, let's start with Christian. Yes, thank you. Morning, Christian. Let's see, your admission date was June 30th. You've got a pending offense of unauthorized use of a vehicle. Let's see, you're currently on 2 terms of probation for theft of property, 2 thefts of property, greater than 2,500, less than 30,000, and then you have that pending charge. This pending charge occurred when you're on your 1st term of probation. You were receiving inpatient services at TYRC when the department received a referral, and your hearing for adjudication disposition was scheduled for June 21st, a month ago. You appeared for that, and the hearing was passed due to a pending psychological evaluation. The department is seeking to recommend placement. You were placed on an EM and a drug test was administered, which showed that you were positive for marijuana. Let's see, on June 22nd, the electronic monitor alerted, indicating that you left your home and walked to the corner of the street from 10:24 p.m. to 10:47 p.m. Subsequent home visit was conducted and you were warned about violating the rules and the guidelines for the EM program. And then on June 29th, your mom reported to probation that she and stepfather conducted a search of your room, and the search revealed multiple small bags of what appeared to be marijuana and some bags of white powder and a loaded 9mm handgun. On the 30th, the next day, a progress report was submitted and a DTA was issued by Judge Porter. And then you were brought in the same day by Arlington PD. So you've got a total of 4 theft of properties and an unauthorized use of a vehicle on top of the current one. The positive on the 21st and 30th of June. I do appreciate that you've been level 1 outstanding since July 4th. I know that's not easy. That's been 12 days. You have your psychological evaluation coming up and you are scheduled for court on August 23rd. Okay. And so I'm going to encourage you to stay on level 1 outstanding. I need to protect you from yourself at this time. So I don't know what's going on out there with all those different little baggies. It tells me that you may be possibly putting yourself in danger. First of all, you're not obeying the electronic monitor program, and you're caught with drugs while you're on probation, while you have pending offenses. And so I'm going to go ahead and keep you here, and we'll see how you do in August. Thank you. Is there a parent here for him? Is that mom? All right. All right. Thank you, ma'am. Okay, Gabriel. Thank you. Okay. All right, Gabriel, you're also on probation. And let's see, you're currently enrolled in FPP. You completed outpatient treatment at TYRC on May 24th of this year, but you've continued to use marijuana as evidenced by your positive sweat patch testing in UA. Plan says it's to be that you're to be admitted to TYRC for inpatient treatment. And then they'll be able to transport you there today if I were to release you. Your probation expires on August 16th, but you actually have a modification hearing set in front of me on the 22nd of this month. All right, so you were brought in also on the 30th on a DTA issued by Judge Porter that same day because of your sweat patch was tampered with, and back in June, on June 15th. They gave you a second one, and then that one was positive for THC on the 22nd. So, all right, Ms. Smith. His behaviors, why is it only level 1 outstanding as of yesterday? Does anyone know?
Yes, Your Honor. He was back on the 10th. He had infractions for continuous talking about pollution, and then also push to appear is what is noted in JCMS. Prior to that, he was on level 1 outstanding for 5 days.
Okay. And if I were to keep him here, would there still be room for him at TYRC once his modification hearing is completed?
Yes, I did contact TYRC, and they said whether he was released today or on the 22nd after the modification.
They'd still be able to take him? Okay. Is there a parent or guardian here for him today? Dad and mom. Ms. Smith, what are your thoughts on this one?
Well, Your Honor, we're obviously, we have some issues with this case. I usually call the lab and speak with someone. I have some concerns just based on conversations that I've had with my client. With that being said, Your Honor, we are going to ask the court to entertain doing something other than inpatient treatment. I would ask the court to hold off on sending him today. If the court does entertain releasing, I'd ask that he be released either back into the care of the father or his sister, who is present here today as well, who has a home that he can stay in, where he will be supervised by his sister. So, Your Honor, I wish I could offer more information at this time in regards to my concerns, but without speaking to someone in the lab, I'm hoping to do that before the 22nd so that I can actually provide more testimony and evidence to the court. Hopefully this is all one big misunderstanding is what I'm hoping.
Okay, well, he's got possession of marijuana from 2018 that was supervisory caution. And then he was placed on probation for a criminal trespass of a habitation. The possession of marijuana was refused without prejudice from June 1st. What I'm saying is it sounds like I know there may be some issues with this, but it sounds like he's got a little bit of a history of kind of doing the same stuff. Is TYRC, I'm not sure where everyone is at with their COVID rules. If he were to go home,
If you were to go home, there would have to be.
you'd have to come back for 14 days again, or at home?
Yes.
At home quarantine.
Mm-hmm. If he was transported from detention, there's no quarantine period.
Dad, what are your thoughts?
Well, you need to tell me the truth. You need to tell me that man you run drugs. There's something wrong. Tell me, I believe, you alcohol, let like her church.
You'd be surprised how many kids test positive who've never left the house. There's what I call a marijuana fairy in Tarrant County. And they find it.
I'm not saying that we didn't do it, I'm just saying that we,
Okay.
being more straightforward, he does a lot of, he does something wrong, he does something, yeah. I mean, he gets to, he does. So, when he's telling me not to, obviously, if I'm wrong, I'm wrong.
Right, and I believe you. I do believe you. I just know that right now he's in here and maybe he may not be being honest with himself. I don't know. It's just, the history is what has me concerned. I don't know.
And Your Honor, if it's helps support, one of the issues that I have, not just presented since you will be the judge presiding over the issue. Obviously, he did test positive at one point. The issue that I'm having is understanding the results and whether they are quantitative versus qualitative. If they just simply picked up marijuana as a positive test, or whether they actually have a quantitative number that I can look at and see if his levels have been decreasing. So that's my issue. The allegation is that he's continued to smoke marijuana. If I can show that the numbers have actually decreased, that will be sufficient evidence, I think, to prove that he has not been smoking. That's where I
Okay. Well, here's what I'm going to do. And Gabriel, well, one thing is you had that hiccup with your behavior, just knowing that you had a detention hearing today coming up. So that right there gives me concern about your ability to follow the rules when you know something's hanging over your head too. So I'm going to help save you from yourself. And if that's the case that you're, we want to get a true read of where your levels are at, I'm going to go ahead and keep you detained. Okay. And because I do think you're likely to just come back positive again and just create bigger messes. I really do. And so I'm going to keep you here and we'll see what happens on the 22nd. Okay. All right. Thank you. Okay, Osborne? Yes. Thank you. Yeah, Osborne, you've also been here since June 30th. Anna DTA was issued on April 21st. Got pending offenses, 2 counts of aggravated robbery, a handgun, in violation of court order because you were on probation when those occurred. It says that on June 30th, you were referred in custody by Fort Worth PD. They say that on the 29th, Fort Worth gang enforcement officers were conducting surveillance at the Stay Express Motel on Beach Street when they observed a vehicle in the parking lot that you were known to drive. Officers knew that you were wanted for aggravated robbery warrants. They approached the vehicle and observed your mother to be in the vehicle. When officers asked her where you were, she advised that you were in the motel and called you to give yourself up. You then came outside to meet the officers and were taken into custody without incident. Warrants and DTAs were confirmed and you were transported here. You were referred for aggravated robbery and then you were detained on June 30th as you had previously been found to be delinquent. See, on April 27th of 2021, officers were dispatched regarding aggravated robbery at the Dillon Apartments. 2 victims were approached by 2 black male suspects who produced handguns and demanded money. Victims produced a total of $600 and the suspects left the location. Victims were able to identify suspects with you wearing a blue jacket with a B on it. Officers reviewed surveillance camera at the apartments that matched the description of what the victims described. Officers notified Fort Worth gang unit and an officer immediately recognized you and Cameron Dukes, 2 documented gang members. Earlier that month, on the 12th of April, officers were notified by Detective Copeland that you had been shot during an offense in the south side of Fort Worth and you were at Harris Hospital. Detective was investigated and reported the reported offense against you as the victim. Detective interviewed you and asked if he could show you a few photos to see if you recognized anyone. He showed you the images of the two suspects wearing jackets first, and you advised that you were the person in the image wearing the blue jacket with the B on it. And then you said Cam was the second individual. Osbon's, you stated that you had known Cameron for several years. And so officer had reason to believe that you did commit the aggravated robbery, and then the warrant was issued. On that same day, officer made contact with you, reported you were shot in the shoulder. You reported the officer you were being dropped off at your aunt's house to meet your grandmother when someone drove by and shot up the vehicle you were in. On the 19th of April, your grandmother reported that you left home on the 17th and failed to return. Officer made contact with you to inform you of an administrative hearing scheduled on the 20th to address you being shot and leaving home without permission, but you failed to show up for that. And then Judge Kim issued a directive to apprehend. You've got a page of here stemming from 2016 of you trying to be here. Positive for marijuana in June when you came in. And you've got court on the 28th of this month. Osborne, I have to encourage you to stay on your best behavior back there. I mean, I don't know why you're trying so hard to be here and to be placed somewhere, but is there a parent or guardian here for him? Oh, that's right. Okay. That's why I recognize the name too. He's one of my other ones. Yeah. Okay. And everyone's been trying to keep you out of here. Everyone on your team's been trying to keep you out of here. You know that, don't you? If you want to be friends with people, those people do not care about you whatsoever. Okay? Whatsoever. Everybody else on your team does, but you got to do your part. All right? I mean, I don't know how much your behavior was going to save you, but if I were you, I would keep it up as high as I could. Okay? I'm going to go ahead and keep you detained. I do feel like you're likely to abscond. Did you have a question?
I always be doing my month to eat. My course up to my niece.
I'm not comfortable releasing you on a monitor. I think you know how serious this all is now, and I'm not comfortable that you won't break the rules in the monitor.
I will come back.
Well, you come back when you want to come back. You know what I mean? But in the meantime, you're out getting shot and getting shot at. It could have been worse for you. Or you're out allegedly doing aggravated robbery, you know? I mean, I'm sorry. I would just keep your behavior level up. You've been doing well the last week or so. Just keep it up, okay? All right. Thank you. Okay, Scarlett. Anyone here for Scarlett today? Okay, yes. Yes, thank you. Okay. All right, Scarlett, let's see, you were brought in, wow, it's been March already. Right, I recall this one because I got the phone call on this one. Let's see, on March 19th, you were referred in custody for the offense of capital murder by terroristic threat or other felony. According to the report, on February 10th, 2021, officers were dispatched to a shooting call near Forest Oak Middle School, where they located a deceased male in a vehicle who appeared to have been shot several times. Officers located 2 phones in the vehicle, both of which belonged to the deceased. Later, investigators learned that the deceased was planning to meet a person he spoke with on Snapchat, which was later identified as you, to smoke and possibly sell marijuana and acid. Says that you arranged via Snapchat to purchase the marijuana and acid from the victim in front of Forest Oak Middle School, which was coordinated to set up to rob the victim, planning to steal drugs, money, car, and a gun. Says that you messaged him after the incident asking if he was okay and stated that you ran because you were scared. Officers interviewed you on March 10th, at which time it was confirmed that you and 4 friends planned to rob the victim of his drugs. Once in the victim's car, you learned that he did not have drugs to sell or money on his person, so you attempted to get him to drive you to the school so you could smoke marijuana. Says that you advised your group of friends by text message and they indicated that they still planned on robbing him. You report the victim attempted to drive away as he saw 2 males approach, which is when they opened fire on the driver's side. An adult accomplice was driving. Another adult accomplice was identified later as a shooter, and the juvenile accomplice in that car was identified as a second shooter. The victim sustained multiple gunshot wounds and was pronounced dead, deceased on the scene. And this is your first experience here. Your parents have reported that you began running away from home last year with your negative friends or run to your boyfriend Raimundo's, one of the shooters, run away with him, and you wouldn't let your parents meet your friends. You would not communicate with your parents when you were gone. They would report you as a runaway every time you would leave. And the longest you were gone is 1 month, and it occurred on 3 separate occasions. The last time you ran away was February 14th, and you returned on March 12th.
Your Honor, before you announce a decision, may I respond?
Sure, yes.
Your Honor, I would like to remind the court that this is the very first time she's had any contact with the juvenile justice system. And she's had at least one parent here every single detention year that she's achieved level 1 outstanding so many times that I could probably cover the table with the certificates demonstrating that. And her parents, her parents have taken steps to ensure that she's not going to abscond, that she will not leave her home without permission. We're asking that she be allowed to go home on an electronic monitor with a sweat patch. And like I said, the parents have taken steps to install alarms to make sure that she's not going to leave. She never tried to abscond or flee from the police with all of this. In fact, she cooperated completely before she was detained in this. And we're asking that the court give her an opportunity to show that she can follow instructions at home just as well as she's following the instructions here. The certification hearing is scheduled for August 17th.
Right, okay.
And of course, as it's in the report there, that she was even in the car when those people began firing. They did not consider her safety, or that obviously did not consider.
Oh, I agree. I mean, because they're not, those people are not your friends. Your boyfriend supposedly opening fire on a vehicle that you're in. I mean, I'm reading the substance abuse history. She began using drugs sometime last year. Parents caught her smoking THC in her room, and it was found in her backpack. She's methamphetamines, THC, Xanax, cocaine, lean.
Psychological evaluation has been completed. Of course, I don't think the court has it before you. But there are other things in there that I think would be an important consideration for the judge.
Oh, I'm sure. I mean, I know this is a child who needs some help. You know, she wouldn't be hanging out with people like this, right? And I mean, but also she helped arrange for it, even just to rob someone. I mean, let's be real. I mean, even if she's here, I don't want to say just on a robbery, but she helped orchestrate that and preyed on someone else and set somebody else up this way who's now dead. I mean, I do understand, Shane, this is tough because she has never had a referral, you're right. This is really tough and she's been doing so well.
Other than staying on one outstanding in the back, that there's not much that she can do at this point to convince the court that she.
Right.
Should earn something to be over from the court side. She's never been, of course, never been on an electronic monitor.
Right.
We asked if she gives this to the family because there are several adults, not only her parents, and I may even arrange their schedule, so there'll always be one parent there. But for me, my own selfish interest, it would be easier for me to support her and be a good advocate for her if I could communicate more freely with her.
I think you're being an excellent advocate for her right now. Here's the thing, just because of the seriousness of the offense and her history of running away, and it sounds to me like for the last year, she's just been kind of out on her own, both for the year previous to being here. I don't know. I mean, and here she's not received treatment or anything like that. And so while she has been good, I'm not comfortable. I mean, I would have to be almost 100% certain that I would trust that she would not run away or something. And I can't do that just because of the seriousness of this offense. I have a duty to protect the public. I'm not saying she'd go out and do the same thing again. This may be a one-off thing, but with her solid history of what she was doing, the road you were going down before you got here, I would feel more comfortable keeping you here and see what happens the next time. And if you want to especially set something with the district judge, with Judge Kim, and if he feels differently, you know, based on her performance while she's been doing, that's fine. But I'm not, just a long pattern you've had, Scarlett, of running off, and the things that you were doing when you were running off and your parents having to look through it a month at the time. That's kind of like you've established a lifestyle. And I want to make sure that you are put into a position where there is minimal or no risk of you going back to that. Okay. So I am going to encourage you. Being on level 1 is not everything, but it's almost everything, you know? Well, I think that's something for you to address with Judge Kim. Okay. I think he'll be the ultimate decision maker on that. Well, he will be, but, and I'm sure you'll see him again before your certification hearing. But at this time, I'm not comfortable that you would not abscond. And here's the thing: if I do release you and you were to go even test positive for marijuana or anything like that, okay, then you are going to make your situation in front of Judge Kim a lot worse. Okay. I understand. I know that you feel that way. It's not, I didn't hear what you just said. I'm not worried about me looking bad or anybody looking bad. I'm worried about protecting you from yourself and possibly from whoever out there that may be have to be an innocent person that's in your path if you're not able to make sound decisions right now. You know, like I said, I'd feel more comfortable having you a little bit more time away from that life, because you have established a life out there, Scarlett, and there's a consequence to that. And hopefully this will all be behind you someday. But right now I'm going to keep you detained. All right, thank you, Ms. Reaver. All right, at this time, the last child is under 14, and so Texas Family Code says that unless the court can make a finding, well, the court shall close the hearing off to the public unless the court can make a finding that the best interest of the public or child would better be served by keeping the hearing open to the public. And there's nothing I can think of regarding this next case that would allow me to make that finding. And so at this time, I'll be closing off the live stream to YouTube. And anyone who is not an officer of the court or involved with this case will have to leave the courtroom. Again, so its attorneys may stay, JPD may stay, or the parents.
Donna,
Yes,
hi, I'm Lynn Rodriguez.
yes,
We were invited by my student and I.
yes. You can remain. You can remain. Yes, you're an officer of the court. Yes, thank you. I'm doing that right now.